Good morning, good afternoon, ladies and gentlemen. Welcome to KCAB International and Friends webinar. Today's webinar is the eighth one, focusing on construction industry in worldwide, jointly hosted by Yoon and Yang, Quantum Global Solutions, and Sultan Al-Abdulla and partners. Actually, just as you were that, just one of the responsibility for MC is to introduce the purpose and the background of each event. But however, my boss, Professor Hi-Taek Shin, just would like, he's waiting for deliver his welcome message to contain the information that I briefly mentioned to you. So without further ado, I would like invite Professor Hi-Taek Shin to deliver his welcome remarks. Prof. Shin is the chairman of KCAB International. He also serves as a governing board member of the International Council of Commercial Arbitration, ICCA. He recently retired from Seoul National University School of Law, where he taught international business transaction and the resolution of commercial and investment dispute arising from cross-border transactions since 2007. Prior to moving to academia in 2007, he was a partner at Kim and Chang, specialized in merger and acquisition, cross-border investment, and the resolution of dispute arising from cross-border investment project. He regularly sits as an arbitrator, both in international commercial arbitration and investment treaty arbitration. Professor Shin, please.
Ladies and gentlemen, it is my great pleasure to welcome you at the 8th KCAB International and Friends webinar. Thank you for joining us today. First of all, I would like to extend my special thanks to our speakers, Ms. Yonsoo Kim of Yoon and Yang, Mr. Thomas Williams of Sultan Al-Abdulla and Partners, and Andrew Woodward and Rob Valenta from Quantum Global Solutions for presenting this wonderful webinar in collaboration with KCAB International. As you may know, the construction industry is one of the industries which are in need of a very efficient and cost-effective resolution of disputes, which may arise at every stage of performing contracts. Accordingly, the construction industry is the most frequent user of both domestic and international arbitration. According to the 2018 International Arbitration Survey conducted by Queen Mary University of London, construction, engineering, and infrastructure industry was ranked at the top of the users of international arbitration. In addition, the Queen Mary survey showed that 82% of those who participated in the survey believed that the use of international arbitration was likely to increase in the construction and infrastructure sectors. KCAB International's statistics show the same result. According to the annual report 2019 of KCAB International, the construction industry accounts for more than 25% of total arbitration cases filed before KCAB International. The reasons behind these statistics might be due to the special characteristics of construction industry and the construction contracts. One of such is that it takes many years to complete large-scale contracts. Therefore, at the time of contract negotiation, you cannot nail down all the contingencies which might occur in the course of the performance. Furthermore, in the process of performance, a primary contractor has to collaborate with numerous subcontractors, vendors, and suppliers. This could be another source of complicated and multi-level disputes among various parties involved in the construction projects. COVID-19 must have interrupted the orderly performance of many construction contracts almost all around the world. The impact would be particularly serious in the MENA region, where many international construction companies are performing big-scale construction and infrastructure projects. Therefore, construction companies doing business in the MENA region should pay keen attention to the arbitration practices in this region in preparation for the potential disputes which might be caused by COVID-19 or other factors. Through today's webinar, we will review arbitration of the disputes in the construction industry in the MENA region in the context of the legal culture and arbitration environment and practice of the Middle East, where many Korean companies are actively doing business. The speakers of today's webinar are among the most experienced and recognized arbitration practitioners having expertise in the MENA region, from Yoon, Sultan Al-Abdulla and partners, and Quantum Global Solutions. KCAB International will continue to host informative sessions on diverse aspects concerning international arbitration and ADR, together with leading international experts in KCAB International and Friends webinar series in the coming weeks and months. Thus, please stay tuned. I hope all of you, your families and colleagues, stay safe and healthy in these turbulent times. Thank you very much.
Thank you, Professor Shin. Next, I would like to invite the first speaker, Mr. Yonsoo Kim. She is a partner at Yoon & Yang with a special interest in construction projects in the MENA region, Asia, and America. Recognized as a leading expert in construction projects in MENA region, English lawyer Yonsoo Kim specialized in international dispute resolution with a strong focus on onshore and offshore projects and possesses extensive experience in EPC contract, bespoke and modified FIDIC basis. She will touch upon construction arbitration in MENA region about 10 minutes. Ms. Kim, please.
Hi, thank you very much, Heehwan, and I would like to give great gratitude to KCAB and Quantum Global Solutions and Sultan Al-Abdulla law firm in Qatar. First of all, I'm very glad to be here with you at this 8th KCAB International Friends webinar. The fierce competition between general contractors for winning new construction projects in the Middle East is still growing. It caused many contractors to lose monies and reconsider available ways to be compensated under the law, for example, arbitration. Hence, it encouraged the development of the legal system in the MENA region in order to deal with such increasing disputes in the construction industry. Today, we'd like to see the overarching and inherent principles that govern the disputes, which have rooted over the Arabic legal culture, including the religion. Also, we will look at the contemporary arbitration environment in the MENA region. I'm just going to share my slide over the webinar now. MENA region is the Middle East and North Africa, which corresponds to the greater Middle East. Islamic Sharia forms the basis for legislation in the region. I'm qualified in the UK, but in MENA region, it's based upon the civil law. And the French civil code has influenced the civil codes of the many MENA countries, including Egypt, which in turn is viewed as the source and model on the basis of which many Arab countries have modeled their laws. And hence Egypt has impacted and influenced the laws of other civil law Arab countries. The MENA region has witnessed progression and development in the construction industry and infrastructure projects over the past 2 decades. Construction disputes commonly rank at the top of disputes arbitrated before institutions in the MENA region. The construction industry is dispute-rich and claims-oriented. Such disputes usually revolve around time, cost variations, liability, or quality issues. Construction disputes also involve multiple parties, for example, employers, contractors, subcontractors, suppliers, insurers, funders, you name it. There are many parties who are involved. So moving on, my first subtopic is the legal principles in the MENA region. I would like to focus on good faith principle, as good faith is commonly cited in various articles in many countries in the MENA region. For example, in the UAE, Article 246 of the UAE Civil Code states that the contract must be performed in accordance with its contents and in a manner consistent with the requirements of good faith. And in Qatar, in Article 172 of Qatari Civil Code, it says, a contract shall be performed in accordance with its provisions and in such manner consistent with the requirements of good faith. I'm going to briefly explain to you why I chose this legal principle, because a lot of construction companies, including the contractors, they struggle because of the liquidated damages at the end of the project. A lot of times in the MENA region, contractors usually issue the extension of time claims. However, the owner does not necessarily give the cost, whilst it's much easier to get the extension of time. In the UAE court, I've experienced that if the liquidated damage is much higher than the actual damage, then sometimes the judge potentially could lower the amount of liquidated damages as stated in the contract. And a lot of times the good faith principle kicks in. That's why I chose this particular legal principle for this webinar. The importance of the principle of good faith lies in the consequences of the breach thereof, where a party's liability is usually aggravated whenever it is established that its acts or omissions were not undertaken in good faith or were proven to be undertaken in bad faith. Good faith is generally not limited to the performance of contracts, but extends to the pre-contractual negotiations. Like in a normal negotiation, there's a colloquial language called like bad cop and good cop. Equally, there is the legal principles such as bad faith as well under the UAE law. LD is an area where common law and civil law principles collide because under English law, LD, once it's set under the contract, it's very, very difficult to challenge the amount because it's already agreed between the parties. There's a pre-estimate of the damages. However, under the civil law jurisdiction, such as in MENA countries, a party may avoid damages by proving that it committed no breach, the breach is attributable to an alien cause or the other party's acts or omissions, the inexistence of a causal link, no loss or harm was suffered or sustained by the agreed party. So depends on the case, but there is a room to maneuver in the UAE if the LD was extremely excessive than the actual harm suffered. In addressing damages or harm in general, some legislation empowers courts and tribunals to quantify compensation through the mechanism set out, such as in the UAE, Article 390, subsection 2 of the Civil Code states that the judge may, in all cases, upon the application of either of the parties, vary such agreement so as to make the compensation equal to the harm, and any agreement to the contrary shall be void. So Article 390, subsection 2, essentially gives the power to the judge to make the compensation equal to the harm. Looking at the Qatari Civil Code, Article 266 and 267, under Article 266, the court may reduce the compensation from what is agreed if the debtor shows that the determination is grossly excessive or that the obligation has been partially fulfilled. Any agreement to the contrary will be void. So in the UAE and in Qatar, the judge has the power to reduce the LD amount. Now, my subsection of today's webinar is arbitration in the MENA region. In the UAE, there's a new UAE federal arbitration law, which was issued on the 3rd of May 2018 and came into effect on the 15th of June 2018. I came back to Korea around January 2018. And upon arrival to my home country, a lot of my lawyer friends in the UAE informed me about this new arbitration law. So I got to know of this, the new law. Essentially, it has a lot of positive improvements of arbitration in the UAE, including measures to improve efficiency and efficacy of arbitration procedures, including interim and provisional powers granted to tribunals. And this, this new arbitration law has such technology-friendly aspect. So a lot of times the witness can be called upon the FaceTime by the modern communication technology. So it has a lot of improvements, and it repeals the existing articles 203 to 218 of the UAE Civil Procedure Code, which now has the name as arbitration chapter. In Qatar, the arbitration law is stated in Civil and Commercial Arbitration Law number 2 of 2017. In Saudi, new arbitration regulations came into force on the 9th of June 2012. In Kuwait, articles 173 and 188 of Civil Procedure Law has the arbitration section. There are many arbitration institutions in the MENA region, such as Dubai International Financial Center, London Court of International Arbitration, DIFC, LCIA, Dubai International Arbitration Center, SDAC, EDCAC in Abu Dhabi, KICA in Qatar, SCCA in Saudi, BCDR in Bahrain, and in Cairo also there's arbitration institutions. But having said that, ICC and LCIA remain the leading arbitral institutions that administer large-scale construction disputes and arbitrations in the MENA region. Now I'm going to be talking about the common causes for dispute in the construction arbitration. There are various parties who are involved in the construction. For the owner-related issues, because of the timing, I'm not going to get into the details of the common causes. But I just want you to look at the contractor-related causes and owner-related causes and consultants, human behavior related and external factors. Moving on to my last topic, which is the enforcement in the MENA region. Generally speaking, the process of enforcing foreign arbitration awards in the Middle East has improved considerably over the past few years. Recent changes in legislation have simplified the procedure for recognition and enforcement in the region. In the UAE court, the enforcement is governed under the Civil Procedure Code. And in the UAE court, obviously UAE became a signatory of the New York Convention in November 2006, which was ratified without reservation. DIFC courts, DIFC is very unique. I'm sure a lot of audiences have already been there. Those who have not, it's essentially kind of like a little inside Dubai. DIFC, it seems to me that although it's part of Dubai, but it sort of has the sovereign immunity nature, not necessarily legally, but in terms of the culture. So The DIFC enforcement was governed by the Articles 42 to 44 of the DIFC arbitration law. In Saudi Arabia, it has been the signatory to the Riyadh Convention since 1983 and to the New York Convention since 1994. And the enforcement law came into force on the 27th of February, 2013. So I am very grateful for the KCAB to provide this platform. And I'm just gonna introduce the other speakers. I'd like to introduce Andrew Woodward. Andrew works at the Quantum Global Solutions, and he's a chartered civil engineer with a contracting background drawn from the delivery of complex civil engineering and infrastructure projects. Based in Qatar, Andrew brings his detailed construction experience to the wider GCC region, helping parties with matters of dispute surrounding the difficult issues of quantum and delay. He often sits as a expert witness in arbitration. So Andrew, could you please start with your presentation?
Thank you, Yonsoo. Thank you for the introduction. And thank you, KCAB, for having us speak for you today. Let me just share a screen with you. And today I will be talking about disruption. And hopefully you can see my screen. I'll make it a wide screen. I appreciate I have a short amount of time. The purpose of this presentation is to give an outline around disruption and to try and make it very simplistic, to give you a simple appreciation of what disruption is. These slides are available and they cover what are the primary claims in construction, a simple program-based visualization of disruption, talk a little bit about measured mile, and then I'll talk a little bit about global claims. And then there's a slide about causation. So I'll quickly move on. The primary claims in construction contracts, the big claims, are matters of extension of time, which is a claim about protection from the application of the damages and the penalties. Accompanying that, typically a contractor will raise a prolongation cost claim. That is the costs associated with the running costs. So they're the offices and your project managers and the costs that have incurred from the extension, from the delay that you've had on the project. The third type of primary claim is the disruption costs. That relates to compensation for inefficient working of your labour and plant. So that's your labour and that's your machines and your equipment. And it relates specifically to an under recovery of money through the bill of quantities. So a disruption cost claim is to be based upon your contemporary records, and it should be based around how you've used your resources. The claim should deal with what is the loss of efficiency of that resource. And it's then about identifying what is the cause of that loss of efficiency. So a disruption claim is about efficiency, which is different to matters of productivity. And I'll come on to this. So here's a simple way to visualize disruption simply by thinking about your program. And here is a typical program. The green bars represent your plan. So this is like a typical P6. This little graph here could be an S-curve describing how that work is to be progressed. And in this example, we can see we're talking about MEP first fix, so a portion of work within a program. And in delivering this work, a contractor will have some bill of quantities rates, and he will have made some allowances for his resources to do this work. And in this example, we can see that we have 4 teams, so 4 gangs or teams working at any one time, delivering this work in 4 months. So in terms of productivity, the plan here is to deliver the work with 4 teams in 4 months which would give you 16 team months of work to do that particular activity. And typically this would be on a program which might be quite a large program, and this work may or may not be on the critical path at any particular time. Now, this planned piece of work may change into an as-built, but it might have 5 different outcomes. So I'm just going to step through those 5 outcomes now. The first one is it could probably get delivered to plan. So my green bars out of P6 have turned into blue bars because I've now got an actual. Some of these bars might go on for a bit longer, but I would tend to ignore the tail end of the bars if the works have got up to above 95% complete. In reality, if you complete the work to 95, 96 or 97% complete, you are effectively complete, bar some odds and sods. And in this example, there is actually a significant delay to the commencement. And so we have a 9-month delay to commencement, but that's a matter for your extension of time claim. In terms of productivity and efficiency, we can see that we've delivered the work in a different sequence, but we've still used 4 gangs and we delivered it in 4 months. So in terms of productivity and efficiency, we've actually delivered the work with 4 gangs in 4 months, which is 16 team months worth of work. And so in terms of a loss of efficiency, it's 16 for the planned minus the 16 for the actual, which means we have 0% loss of efficiency, a 0 reduction. So in this example, there is no disruption to claim. So that's if you deliver it to plan. Second option is you might see some loss of productivity, but not necessarily a loss of efficiency. So in this example, we have the delayed start, but instead of doing the work in 4 months, we're doing it in 8 months. But for some reason, we've only used 2 gangs rather than 4 gangs at a time. So it's taken twice as long. So both the delayed start and the prolongation of this work might be an issue on the critical path and might need to be the subject of an extension of time claim. But in terms of disruption, what we have is we have 2 gangs doing the work in 8 months. So our actual productivity is 2 times 8, which is 16 team months to deliver the work. And our planned was 16 team months. So again, there's no disruption, there's no loss of efficiency. So there's no claim for disruption in this example. So third option then, so just quickly move on. The third option then is this example where we have both a loss of productivity and a loss of efficiency. So again, we've got the delay to the start. We're only using 2 gangs, but rather than the work being done in 8 months, it's now taking 11 months to complete the work. So our delivery here is now 2 teams times 11 months, which means we've used 22 team months worth of work to deliver this activity. So now we do have a loss of efficiency because we've used 22 resources or 22 units of resource against the planned 16, which means we've overrun by 6 team months. And that's about a 38%, a 40% drop in efficiency. Now, in terms of a disruption claim, you may want to run a disruption claim for this. But in doing so, you have to have good reasons why you've only used 2 gangs rather than the planned 4 gangs. And then you have to give good reasons why each system has allegedly taken longer to do the work. So that's option 3. Now option 4 is a loss of efficiency only. So this is acceleration. So in the example here, we've got the delayed start. We have delivered the work in 4 months, but the bars in here are so much denser that represents the fact that we're working on 6 activities at a time rather than the 4. We've got 6 gangs in there rather than the 4 gangs. So that's an acceleration. So again, in terms of the units of work, we've now got 6 gangs by 4 months, which means we've consumed 24 team months in delivering that work, which, as you compare to the 16 that we planned, means that we've overrun by 8 units of work. So that represents about a 50% drop in efficiency. It's taken so much resource to do the same work in the same period. So if you want to run an extension, run a disruption claim around this, you have to give good reason why you're using 6 gangs rather than the planned 4. And you still have to show why each system is still slow in its delivery, because each of these bars has got longer than the planned. So that's an acceleration claim. Now we come on to my favorite, which I call the Middle Eastern loss of productivity and efficiency. So in this example, we can see we've got the 9 months delayed to the start, same as all the others. Now, interestingly, instead of having 4 gangs operating, we've got 6 gangs operating at any one time. And those 6 gangs have taken 11 months to complete the work. So the units of work and the actual productivity is 6 by 11, which is 66 team months worth of work and worth of effort executed to complete this activity. And you compare that to the 16, which was the plan, that means that we've overrun on the resources by 50 team months. And 50 team months over the plan 16 is a drop of efficiency in the order of about 300%. And that's a huge number. But that 300% is not unusual in the Middle East. It is typical for problem jobs to have overruns and losses of efficiency of 200%, 300%, 400%, even 500%. So this is not unusual. This is very common, certainly in the MENA region. So that's a simple way to visualize disruption by using your program. I'll just quickly talk about measured mile. Measured mile is all about work that is repeated, has a lot of trades with repeatability in it. So it could be lifts whilst you're building tower blocks, or it could be sections of viaduct whilst you're installing railways. Very simply, the measured mile is about comparing your planned work over a period of time to what could be the actual way you've done the work over the same period of time. So we have a planned unit of work. You then start, there's a period of learning that the contractor will go through. So you're not expected to get up to speed very quickly. But then you may enter an impeded period. This is the period where you are impacted by the works. And then once the impediment's finished, you then have an unimpeded period where you're free to get on with the work. The highest peak that you might have here is the best unit of work that you've achieved in delivering that work. So the difference between the planned and the best is the discount that you as a contractor have to give away as it reflects your poor performance. Alternatively, this line might go up above because you might be better, but that's your issue as a contractor. In terms of a claim, your claim is for this reduction in resource in this impeded period. And so your claim is the reduction in the impeded period. And the way you do that is you comparing what is the best productivity that you could have achieved as the highest part of the benchmark, and then you're claiming the difference between that and what you've actually achieved during the impeded period. So that's how measured mile works. In terms of global claims, I'll just quickly say you can raise global claims, and they're the most common types of disruption claims that we see. you just simply tot up your resources on a histogram, apply a rate to it, deduct some allowances, and then you might add on a percentage deduction to split the cost into contractors' own inefficiencies and the employers. Typically, though, in global claims, that is made up. And so as a consequence, global claims will fail. They might give you they certainly won't give you interim relief. It'll only give you a number to put into a final account. And if your relationship with the employer is not good, your global claim will fail. I've included a slide for typical causation. I won't talk through this because time is tight, but that gives you typical causation that we see for particular types of disruption claim. And that's me done, and I think we're leaving the questions till later. So I shall just end my slides. And I believe we're passing on to, I think is it Rob next, Yonsoo?
Apologies, Rob. I would like to give the floor to Thomas Williams. I'm so sorry to Rob, because Thomas Williams is an English qualified barrister and a partner and leads the firm's arbitration practice. He specialized in domestic and international arbitration and litigation. He's an experienced advocate in arbitrations under all of the major institutional rules and in ad hoc arbitrations, and has also appeared regularly as an advocate in the English High Court, including the Commercial Court and the Court of Appeal. He has substantial experience in international cases and frequently works with overseas lawyers in common law and civil law jurisdiction. I would like to give the presentation time for Thomas. Thomas, could you please start?
Morning, everyone. Can I be seen and heard?
Yes, you can. I can hear you.
Great. Well, a very good morning to you all, and thank you for coming to this webinar. Particular thanks to KCAB and Quantum for the very kind invitation. Particular thanks to KCAB for bringing us all together, for managing the logistics. It's quite an effort to organise something on an international footing, but it's been done absolutely effortlessly. So my thanks to KCAB for that. And also my thanks to Yonsoo and Andrew for their presentations, which I think are an excellent background to what I'm going to be talking about. Andrew's presentation may be in particular a useful reminder to us all that these issues arise and have to be resolved in the real world. I'm going to be talking today about how Qatari law looks at the termination of construction contracts. So if we could just please go to the first page of the slide presentation. Thank you. The starting point to all of this is freedom of contract under Qatari law. Parties are free to choose the termination provisions that they want in their contracts. And of course, you don't just have what's in your contract, you can also pray and aid the wider law, in this context, the Qatari Civil Code. Now, I've mentioned FIDIC on the first slide. Now, FIDIC could be a topic of a webinar in its own right, but obviously FIDIC has its own particular termination provisions, and any FIDIC terms which are present can, of course, like any contract, be supplemented by the general law under the Civil Code. Now, there are various scenarios which could trigger the termination of a contract, and I list those below, and I'll deal with them in order. First is termination by the employer, then by court order, by contract, and then termination as a result of impossibility of performance and force majeure, and then defective work, and finally delay. So we can go to the next slide, please. Now, under Qatari law, Article 707, the employer can unilaterally terminate a construction contract. It's what we would, in the common law world, call termination for convenience or termination without cause. And this gives the employer the unilateral right to withdraw from the contract. Now, if he elects to do that, he must compensate the contractor for works completed and any loss flowing from the inability of the contractor to complete the works. It's worth looking at Article 707, so I'm going to read it. The employer may disengage himself from the contract and suspend the execution of the contract at any time before completing it, provided that he indemnifies the contractor for all the expenses he has incurred and the works he has accomplished, as well as the gain the contractor would have achieved had he completed the works. So that's the compensation in terms of loss of profits. However, the court may reduce the indemnification due for the gain the contractor has lost if conditions render such reduction equitable. The court shall in particular deduct from the compensation the portion saved by the contractor as a result of the employer's disengagement from the contract and the gain he might have earned from using his time for another work. Now, the amount of compensation payable in these circumstances of termination by election without cause can be pre-agreed in the contract. If it hasn't been so agreed, then it will be determined at large under Article 707. If it's pre-agreed, but the sum which is prescribed is unreasonable, it can be adjusted under that article. So we could go to the next slide, please. Now, termination by court order. I'm taking it in this way round, looking at termination by court order first, and then looking at termination under the contract, because unless your contract gives you the right to what we in the common law world would call self-help rescission, you have to go to the court to get out of your contract, to terminate the contract. So the starting point, if you like, the default position is Article 183 and the rights arising thereunder. So let's just look at that. Article 183 of the Civil Code. In contracts binding on both parties and imposing reciprocal obligations, where one of the parties fails to perform his obligation, the other party may, upon formal notice to the former, demand performance of the contract or its rescission, and may claim damages caused by such failure to perform. So under that provision, you can either get out of the contract or you can insist on performance, which is the position in the common law world. Subsection 2, the judge may mutatis mutandis, which is a Latin way of saying you flip the position, but in the same manner, you treat the position in the same way, determine a period of grace within which the obligor shall perform his obligation. The judge may also reject the application for rescission if the obligation not performed is insignificant compared with the obligations considered in their entirety. So the court has a discretion as to whether or not to order rescission in circumstances where the breach is de minimis, and that's entirely sensible. So we'll now look at termination by contract, if you may, just over the page. And as I say, if you want to be able to terminate yourself without going to the court, you have to specify it in your contract. You have to give yourself the right to self-help rescission. The genesis of this right under the Civil Code is Article 184. It may be agreed, note agreed, that the contract shall be considered automatically revoked without the need for any adjudication, which is another way of saying without trotting off to the court and getting an order, in case of failure to fulfill the obligations arising therefrom. Such condition or agreement shall not result in restricting the judge's authority in respect of rescission unless the contract statement indicates explicitly that it was the intention of the contracting parties. So again, the default position is that you have to go to court unless there's an explicit provision in the contract permitting you to terminate in the contract. The condition considering the contract automatically revoked in other than commercial matters shall not exempt the concerned party from serving the notice. No agreement by the parties to the contrary shall be valid. So again, the primacy of giving notice. And if there's a contractual provision that says that you don't have to give notice, then such a provision is void. So if we now go to termination under impossibility of performance. Now, impossibility of performance and force majeure, which is the next slide, are perhaps particularly relevant at the moment given COVID and the difficulties that contractors and indeed everybody is facing. They simply can't often perform what they've contractually agreed to perform. And the question is, well, what is the remedy in those circumstances? Now, at its heart, force majeure is all about impossibility. It's about an unforeseen event that interposes itself in the contractual arrangement, which renders it impossible for the parties to perform. Now, you might say to me, well, what's the distinction between impossibility of performance on the one hand in Article 704 and force majeure and the other provisions that we're going to be looking at under that heading? Well, the difference is really one of definition, because under Article 704, the words force majeure are not used. They may well amount to the same thing, but given the fact that the words force majeure don't appear in Article 704, it seems to me to be analytically right to give them separate treatment, even though in substance, the rights which accrue under 704 are the same in substance. So if we look at Article 704, this talks about impossibility of performance due to matters which are beyond the control of either party. The contracting agreement shall terminate if the agreed work is impossible to perform due to a foreign cause beyond the control of either party. Now, don't be put off by the word foreign. It doesn't mean necessarily outside the country in which the contracting parties are operating, where the project is, where performance has to be. It just means an extra contractual cause. But note beyond the control of either party, note those words. In such event, the contractor shall have the right to demand the employer to reimburse any costs incurred by the contractor and such wages payable to him commensurate with the benefit obtained by the employer from such work. So that's Article 704. And now we come on to what might be called force majeure proper. And we find that the Civil Code gives full-throated recognition to force majeure in Articles 187 and 188 of the Civil Code. Now, contracts often, usually, make provision for force majeure. And what a contract will do is it'll adumbrate the circumstances which can give rise to force majeure, the force majeure circumstances. Now, even if a contract doesn't, you still have Article 187 and Article 188. It's worth looking at each. Article 187 provides, in contracts binding on one party, where performance of the obligation becomes impossible due to force majeure, beyond the control of the obligor, the contract shall terminate automatically. Where such impossibility is partial, the obligee may enforce the contract to the extent of such part of the obligation that can be performed. So the law recognizes that contractual obligations can either be impossible in toto or partially, and the contract will be enforced pro tanto if impossibility is only partial. And again, that makes sense. Article 188 then, which deals with contracts binding on both parties, where performance of an obligation by one party is extinguished by reason of impossibility of performance due to force majeure, beyond the control of the obligor, such obligation and correlative obligations should also be extinguished and the contract deemed rescinded ipso facto. Where such impossibility is partial, the obligee may either enforce the contract to the extent of such part of the obligation that can be performed, or demand termination of the contract. So the difference between 187 and 188 is that 187, contracts binding on one party, says that performance will continue if impossibility is only partial, whereas in 188, which deals with contracts binding on both parties, if there is partial impossibility, then at the election of the obligee, there can be an insistence on full performance, even if there's an only partial impossibility, or there can be a demand for termination. If we just go over the page to termination for defective work. Now, if a contractor is performing the works in a defective manner, then there is a right to termination, and that is enshrined in Article 688. Let's look at that. If during the progress of work it is established that the contractor is performing the work defectively or contrarily to the contract, which is another way of saying in breach of contract, the employer may warn him to correct the method of execution within a reasonable period he defines for the contractor. If this period expires and the contractor fails to use the right method, the employer may then request cancellation of the contract or obtain a judicial authorization to execute the work at the contractor's expense if the nature of work so permits. Cancellation of the contract may be requested without notice or fixing a time limit for correction if correcting the defect or violation is impossible. So if the defect can't be remedied, you don't have to give notice or provide an opportunity to correct. And again, that makes sense. In all cases, the judge may reject the cancellation request if the execution defect is not likely to greatly reduce the value of work or its fitness for the intended use without prejudice to the right to compensation if necessary. So if effectively the defective works are going to have a de minimis effect, then the contract won't come to an end, but that's without prejudice to the right to seek compensation. So, finally and quickly, termination for delay. An employer can terminate the contract if the contractor doesn't meet its contractual completion date or is unlikely to. And that's a right enshrined in Article 689 of the Civil Code if the contractor delays in commencing the execution of work or completing it to an extent that he is not expected at all to complete it within the agreed period, or if he resorts to a course of action indicating that he does not intend to fulfill his obligation, which in English law would be an anticipatory breach of contract, or commits an act liable to render the fulfillment of such obligation impossible, the employer may request cancelling the contract without waiting for the term fixed for handing over to fall due. So if there is what we would say in common law, an indication of an anticipatory breach of contract, in broad terms, I don't intend to fulfill what I've got to do such that the completion date will not be met, or what the contractor does is he behaves in such a way that makes the contractual end date impossible to achieve. Note the word impossible, it's a high threshold. Then there can be a cancellation of the contract, a termination of the contract. Now, just dealing briefly over the page of consequences of termination. I mean, really, this is what it's all about, because on the one hand, you've got to make sure that you correctly terminate, because if you don't correctly terminate, that wrongful termination can itself be a breach of contract, and you can end up in a very difficult situation indeed. But it's equally important to look at what the consequences of termination are as well. Now, under under Qatari law, if we just go over the page then to consequences of termination. Could we go over the page to consequences of termination? Thank you. Now, if under Article 185, there is a termination of the contract, the contract as a matter of law is treated as void. And what that means is that the parties will be restored to their previous positions as if the contract had never been made. And under the English common law, that's known as a restitutio ad integrum. You're restored to the position you were in prior to the contract. Now, usually what happens is a contract will prescribe what happens if there is a termination and how you calculate the value of the work, a computation of the relevant figures for deducting or recovering the additional cost of completing the remaining incomplete works and so on. But what Article 185 does is it sets out the general position that there will be a restitutio. Now, in a lot of cases, it's impossible to restore parties to their pre-contractual position. And we're used to looking at this in the common law when looking at restitutionary remedies. And often it's not possible to put the parties back, to restore them completely. Now, if it's not possible to restore them completely, then the law doesn't impose a restitutio ad integrum, and you have compensation instead. So without further ado, then I will hand over to Rob. I'm very grateful to you all for your time. There is a brief summary on the final page. I don't intend to read it out, but that's merely a summary of the key points that I've raised during the course of the presentation. Thank you very much.
Thank you very much, Thomas. I really appreciate it. Rob Valenta is the creative director at Quantum's sister company, Quantum Media. He looks after Quantum's in-house media studios in Doha and London, where he manages talented teams of designers and artists in both studios. Rob is responsible for the creative direction of Quantum's unique multimedia solutions, publishing and creative marketing. Rob has a BA in art and design, specializing in technical illustration and informing graphics. Rob, could you please begin your presentation? Thank you.
Right. Yes, thanks very much, Yonsoo, and thanks to Thomas for your excellent presentation. So, yes, my name is Rob Valenta, and this afternoon I'll talk about something very, very different. I'll talk about the use of graphics and visual aid in construction disputes. So, well, what we also call forensic graphics. So let's look at the concept of forensic graphics used in construction disputes. So we all recognize this, a typical written submission for a construction claim, Volume 1. We also have Volume 2 and Volume 3. And this is only the executive summary, which is then followed by boxes of backup documents. So using this traditional approach, we have a lot of technical paperwork to read and understand. There will be numerous meetings and conference calls, and yet there will be misunderstandings and doubts. So to make all these documents easier to understand and to avoid any misinterpretations and doubts, 3D animations like these are being used. So in most cases, these animated movies have a professional voiceover timed to all the visuals that you see here, which means the technical issues are being visualized and explained at the same time. So it's therefore guaranteed that visual images will be implanted into people's head as visual reference points. So using forensic graphics or visual aid in construction dispute, it's designed really to get people interested in your problems. And if you can get people interested in your problems, there will always be a way forward. And that's exactly what visual graphics or forensic graphic does. So over the years, I've attended several construction disputes where forensic graphics has been used. And I just want to highlight some of the benefits in using this very unique approach. First of all, forensic graphics is a unique supplement to a written claim. So sometimes people think that a written claim and forensic graphics are two different things. No, they all go hand in hand. So as I say, an animation of a dispute is like a trailer for the documents. For higher management level, who doesn't have the time to read all these documents, forensic graphics makes it easier for them to get a good overall view of how the arguments are being presented and to evaluate the directions his team has chosen to showcase the argument. If it's done correctly, forensic graphics can only be understood one way. So this is particularly useful in joint ventures where you have contractors from all around the world with different backgrounds, cultures, and languages. Here there is a need for a common language that everybody understands, and visual graphics just does that. Everybody understands imagery and animation in the exact same way. Psychologically, in using forensic graphics, it shows that you're well prepared. And this is exactly how you will present all future disputes, which I can promise is very difficult to counteract, so it will speed up negotiations, or you will have, or you will get really the benefit of doubt in an argument. So these are really the 6 points that I've seen are the major benefits in using forensic graphics in construction disputes. So let's look at different examples of forensic graphics, different formats. So the first format is 3D construction sequences. The next format, which is a very popular format, are called claim movies. An interesting format is when film footage or photography is combined with graphics, and then we have interactive presentations. So let's look at 3D construction sequences. This one is for the iconic, or this construction sequence is for the iconic FIFA Lusail World Cup Stadium in Qatar. This construction sequence was actually used for a tender where the contractor wanted to give the employer the confidence they could build this stadium and that they are well prepared. So here we see at the bottom of the screen, we have the timeline representing the total planned construction duration, whilst in the top half of the screen, there are detailed animations of the various stages of the planned construction sequence. When a planned construction sequence is compared with the actual construction sequence, that's when it becomes more interesting and forensic in nature, ideal for disputes, like this example for commercial development. So as you can see here, one of the standards in producing construction sequences for disputes is always to use the familiar colors of Primavera: green for planned, blue for as-built, and red for delay, changes, or loss of money. For construction sequences can also be based on days rather than months, like this example where we look at changes to the formwork on one floor, which was then multiplied to the total amount of floors to then showcase the overall impact. Going more into details means that we can show more detailed animations of what actually went wrong. So this is a very good way of doing this. So construction sequences can be months, days, or even down to hours. The next format are forensic movies, a very popular format, especially in the Middle East, with joint ventures. So a forensic movie is like a short documentary movie of a project that explains the planned intentions compared to what actually happened and what impact the changes had on the contractor. A professional voiceover is narrating throughout the movie, to which all the visuals are timed to. So it is literally a short documentary movie. So these type of documentary movies, or forensic movies as we call them, they vary in duration, but the preferred length is around those 10 to 12 minutes. because our visual concentration span just doesn't go any further than that. To showcase, I will showcase you an example of a forensic movie, but I've taken a 12-minute movie and cut it down to 2 minutes. But that still gives you a good idea of what it looks like when visuals are timed to a voiceover narrative. So you'll see some jumps in this example, but it's only because I've cut it down from 17 minutes. So here we go, the cooling plant buildings at Hamad International Airport in Qatar.
The engineer stated that the modification and details would be incorporated into the CP99 contract after award by way of a change order. However, that did not happen straight away. As a result, the contractor was delayed from immediately proceeding with Cup 2 design as planned. The contractor suffered delay to the completion of Cup 2 design as a consequence of the increase in design scope of work arising from the employer's modifications to Cup 2 building. Outside, chilled water pipes and standby power lines were now additionally required to be installed from the Cup 2 building to the catering facility building. Within the Cup 2 building on the chilled water side, the capacity of the original 8 chillers was increased from 2,000 tons to 2,500 tons, and foundation sizes also increased. The increase in size of chillers meant that the capacity of the cooling towers was also required to be increased. Claim 13 deals with more than 20 employer issues relating to change of design which are not covered in any of the contractor's other claims. For example, due to an oversight in the employer's preliminary design, the number of roof-mounted exhaust fans at Cup 2 had to be further increased from 9 to 18. Additional steelwork was required in the roof to support all the additional and enlarged exhaust fans. The nominated generator supplier increased the number of radiator fans it was supplying for the generator's cooling system to each cup from 5 pairs to 6 pairs per cooler. Here we see the combined effect of the claims and change orders. More than 45,000 additional design man-hours were required across the 3 cups.
So what was great here, as you just saw, across 2 minutes, we showcased nearly 30 design changes. Very high level, not into details, but 30 design changes was visualized over 2 minutes. And it was all done in a logical manner of this changed, which impacted this, which then meant this has to change, which meant that this increased and so forth. Not going into details, but over 2 minutes, 33 design changes was showcased, which is really impressive. So rather than one, let me just play this. So rather than one long movie, as we have just seen, we can also have a series of short individual 2 to 3 minute movies, with each movie covering a separate topic. Like this turning example for a mediation in British Columbia in Vancouver, where the legal team chose to use a series of short movies, each with a voiceover, obviously, but short movies rather than one long movie. What I've seen is that in UK, this seems to be the very preferred choice, to have short movies rather than long movies, but it's all down to the type of story that's being visualized. But during this, what was interesting was that during this tunneling mediation, the mediator, he regularly came into the contractor's room to just have a look at this certain element in this particular movie. So it was obvious the mediator used these movies as a visual reference point. And that is really what it's all about, that if it's accurate, factual, and informative, what you are showing and telling, then it is being used as a visual reference points. So that's why I always say it's important to always be the better teacher rather than the better preacher. Decision makers, they want to make their own decision, make their own conclusion, but they don't necessarily feel they have the right grasp of facts to make that call. So if you can be accurate, factual, informative, there will be a way forward and you will be acknowledged for your effort on some level. So the next format are the use of film and photography. So this is where computer graphics is overlaid on film footage. So here we see film footage of a wasteland, and then we have overlaid some graphics of a road. This was for an arbitration in Dublin for the M50 highway arbitration. So you can see how we have overlaid some graphics on top of some very simple footage. And it's again, just to make it easier to understand and to really bring the message across that these were the arguments that the contractor faced on this project. The barrister in this arbitration described this approach as hitting the moral high ground because of the subtle and factual way the film footage and graphics were used to make it more meaningful. And from our point of view, this was very simple, but it was very effectful. So forensic filming doesn't have to involve a setup like this, where we have a cherry picker filming down to make a reconstruction of the road project, but it can also be based on weekly film footage from your weekly report. So for this hospital project, we used progress filming from the weekly report to visualize the issues relating to the MEP services. So we used footage of the workers to give the animation scale, but also to emphasize the height restrictions the contractor suddenly had to work within. So here we have footage of people there working while the ceiling void is going up and down. For a project in Iraq, what we ended up doing was just to use photography. There was no 3D animations of any kind, just photography where we flashed in red the changes on the phase 1 and the phase 2 project. And this was really, really effectful. It was used in a DAP hearing, which went our client's way. So again, it was one of these where we looked at it. The client originally wanted some animations. We said, no need for that. Your story is strong enough. You have good photography. Let's just use that. So it doesn't have to be a long, well, it doesn't always have to involve 3D animations. Here we have a 3D animation of a metro project that we then fade into photography. I always recommend this use of, if we have animations, that we can always relate it back to photography. Everybody loves photography. Animations, they are synthetic. If we can fade in or compare that or relate that to photography, it gives so much more weight to your animations and to your arguments. So that will be one of the things I always ask for. What kind of photography do you have of the site, and what photography do you have specifically relating to the arguments that we are showcasing? So the last format is interactive presentations. I'm not going to talk much about that today, simply because of the time restrictions. So really, I just want to jump in and say, well, just talk a little bit about myself, really, that forensic graphics, you know, I'm basically a forensic artist producing forensic graphics. So these type of people are very difficult to find. There's not many of them. And my career started many years ago with the London Metropolitan Police here in London, of course, where I was involved in creating 3D reconstruction of crime scenes. So for some reason, I was always involved in kidnap and murder scenes. So it was a seamless transition getting into construction disputes. But my point I want to raise is that working for the Metropolitan Police, I had to follow very strict guidelines very strict guidelines to ensure that all my work could pass or hold up in court. And those guidelines is what I've then taken into forensic graphics that we are now offering as a service at Quantum Digital. So some of these guidelines, for instance, there were that all the 3D modeling, if there was any animation, all the 3D modeling had to be within 0.5 millimeter accuracy. If it was not within that region, it would fail in court. I could not use any directional sun as it would imply a certain time of the day. I could not do anything that was over the top, like that's for Hollywood. Like the example I showed you from the tunnel project in Vancouver, that originally the animations we did, it had like a tunnel collapse, debris flying everywhere, smoke, particles, and so forth. They looked fantastic. I had to say to the team, listen, guys, we cannot do this. If we show this in court, we have to bring in a smoke expert, somebody who studied rock formation for the last 20 years. We can simply not do that. And that is very important. And that's the big pitfall that a lot of 3D animators or artists, they like doing all these things. But for forensic graphics used in a dispute or for the Met Police, you cannot go over the top. Other guidelines was that we could not use any audio or sound effects, it would evoke emotions. And for instance, with the camera, we could only use down to minimum of 25 millimeter camera. Otherwise, we are distorting the reality. So these were just some of the strict guidelines to ensure that forensic graphics produced was always accurate, factual, and informative. So that's a discipline that we are strictly follow, and to date we haven't had any.
Sorry, Rob. Yeah. I just wanted to inform you that you ran out of time. Apologies, because it's an hour webinar.
I'm finished now.
So apologies.
I'm finished now. So thank you very much for your time.
Thank you very much, Rob.
Thank you, everybody. Just thank you, Yonsoo, Rob, Andrew, and Thomas. Now, we are almost 1 hour, 15 minutes. So we have very, very limited time. But after we got a question, and I also got personally have several questions. So maybe within 5 minutes, I will consume some questions to each presenter. First of all, to Rob. Actually, as well that if a client had money, then maybe probably their business partner probably digging to the client head or mind that brings the whole idea without having the assistance of just client. But however, in the real cases, the clients also maybe need to pay attention. So from the perspective of client, what you need to produce this wonderful mechanism?
That's a very good, that's a very good question. The story. I mean, the most important part is the story. So it will normally start with, I will be given an executive summary of the claim, which I would then convert into a voiceover script. And that is really what takes the longest, is to put that voiceover script together, make sure the client is happy, and so forth. So I will say it all starts with an executive summary of the claim. And once we have to produce the voiceover script that will be narrated, and once we have that, I will then be able to ask for BIM models, photography, and other kind of reference material.
Okay, so Yonsoo, can you recognize the question raised by my friends James Dingra based on Singapore? He's raising a question regarding the LD issue. Could you answer for him?
Yeah, sure. Basically, the question is regarding whether I came across some cases in MENA where actual damage is proven to be more than LD, then the court would allow more or only agreed maximum LD. Answering to James' query, I would like to draw your attention to the Saudi court, especially the reason for me to choose Saudi Arabia is because the judge or arbitrator is very much likely to award the actual harm or actual amount rather than whatever is stated in the agreement. The reason for that is because in Saudi, the court or the arbitration tribunal, if the governing law is Saudi law, is only looking at the actual harm. So answering your query in relation to if I came across some cases in MENA where the actual damage is proven to be more than LD, yes. And I would like to give you an example in Saudi court.
Okay, so I got just one question to Thomas. Actually, from the perspective of clients or a user, the most important thing is how to enforce that they're just winning award in foreign jurisdiction. So in case of MENA region, I heard that maybe just the Riyadh Convention. Riyadh Convention is very, very important to regarding of enforcement. So could you briefly explain about just the Riyadh Convention?
Sorry, could you just, is that a question for me?
Yeah, I heard that just to enforce foreign arbitral award in MENA region, people should be just aware that just Riyadh Convention is kind of just a Middle East version of a New York Convention. So could you briefly explain just what is the function and how many countries are signatory of Riyadh Convention?
Yeah, so I just practice in Qatar rather than in Saudi Arabia. I hadn't come across the Riyadh Convention in operation. I'm obviously aware that it exists. I've never read it. I've never had cause to apply it. If it's anything like the New York Convention, it would operate in a way which enables you to take your arbitral award and enforce it in the country where there are assets in the same manner that you would if it were a judgment of that country itself. And so it's a very streamlined process. But beyond that, I can't comment on the Riyadh Convention and its peculiarities or particularities, if any.
What about Yonsoo? Do you have any just further comment to add, Thomas mentioned?
Yeah, the Riyadh Convention has 18 state signatories from across the Arab world, i.e. UAE, Jordan, Bahrain, Tunisia, Algeria, Djibouti, Saudi Arabia, Sudan, Syria, Somalia, Iraq, Oman, Palestine, Qatar, Kuwait, Lebanon, Libya, Morocco, Mauritania, and Yemen. Whereas the total of the New York Convention signatory states now stands at around 160, which is around 80% out of a total 195 countries in the world. Most recently, Sudan and Sierra Leone became the signatories of the New York Convention. Riyadh Convention deals with the recognition and enforcement of foreign judgments and arbitral awards without reviewing the subject matter of the underlying dispute, provided that such judgments or arbitral awards do not violate public order, morality, or the constitution of the state.
Yeah, so it seems, just coming back, Yonsoo, thank you for that, with your particular knowledge of the Riyadh Convention. It seems that it's really the New York Convention in another name.
Yes, now just we are living in the world surrounded by just many international conventions such as the Singapore Convention, Europe Convention, and Mauritius Convention, and probably just something new came up soon. Okay, so everybody, just thank you for joining once again, Yonsoo, Thomas, Andrew, Rob, and all participants. Actually, just today's webinar is very, very impressive from the perspective of KCAB International. So according to the participant list, we have just many new names from just the MENA region and the other jurisdictions, definitely just including Korea. So I would like to just extend our just very cooperative relationship with just a very reputable firm, such as Qatar, based in Qatar and the other MENA region, and I actually promise that to provide more meaningful webinar together with this wonderful firms and institutions soon. Please stay safe and stay well. Thank you so much.
Thank you.
Yeah.
Thank you. Goodbye.
Thank you.